Functional Area 3, Part 2, Benefits and Leaves of Absence. Providing employees with time off benefits in California is both required, as in paid sick leave, and optional, as in vacation. However, even optional benefits like vacation have specific rules that must be followed if provided. California's Healthy Workplaces, Healthy Families Act requires all employers to provide paid sick leave to most employees who work at least 30 days in the state of California. The law specifies that sick leave can be given in several different ways. It can be provided up front all at once. It can be accrued at no less than 1 hour per every 30 hours worked. It can be accrued at some other measure so that the employee has at least 8 hours available by the time they have completed 120 days of work. When applied to employees working under an approved alternative workweek schedule of 4 10-hour days, those employees should receive 30 hours of paid sick leave, which equates to 3 days. If applied to employees who are working less than an 8-hour day, for example, 6-hour days, those employees will still be required to receive 24 hours of paid sick leave, so in this case, they would receive 4 days. On July 13, 2015, Governor Jerry Brown signed updates to this law, effective immediately, which included grandfathering plans that accrued at least 24 hours or 3 days annually and that had already been in place prior to January 1, 2015. It is also important to note that several California cities have local sick pay ordinances. Employers with employees located in these locations must ensure that they are aware of such local ordinances so that they provide sick time pursuant to those laws. Eligibility requires that an employee be employed by their current employer for at least 30 days before sick leave may be accrued. The employer can limit use to after the first 90 days of employment, and employers can cap accrual at 48 hours per year and can limit the use of accrued paid sick leave to 24 hours or 3 days per year, either calendar or anniversary. Use of paid sick leave can be required in increments of at least 2 hours. Paid sick leave can be used for the diagnosis, care, or treatment of an existing health condition or preventative care for themselves or a qualified family member. It may also be used when the employee is a victim of domestic violence, sexual assault, or stalking. Under this law, a qualified family member is a child, a parent, a spouse, a grandparent, a grandchild, or a sibling. Employers are required to approve sick time requests, whether given orally or written. When utilizing paid sick leave for preventative care, that is, treatment that was scheduled in advance, the employee must provide their employer with sufficient advance notice. If an injury or illness was unforeseen, the employee must give notice as soon as practical. Employers are advised not to request medical certification for use of sick leave unless that certification is necessary for administering another leave of absence request. When utilizing paid sick leave, an employee should be compensated at their regular rate of pay. If the employee received variable rates of pay, the employer can decide to utilize one of two methods. First, they can average the straight time wages over the immediate 90 days preceding the use of the sick time. Or second, they can average the straight time wages for the pay period during which the sick time is being used. Since paid sick leave is not required to be paid out to employees at termination, employees that are reinstated within 1 year of their termination are required to receive and have available all accrued and unused sick time at the time of rehire. If an employer utilized a qualifying PTO or paid time off plan and has paid out all accrued and unused PTO at the time of the employee's termination, there is no requirement to reinstate any sick time. This act prohibits employers from discriminating against employees who exercise their sick leave rights under the law. Employers who have Policies regarding disciplinary action after tardiness or absences should ensure that their policy does not utilize these protected days in their disciplinary determinations. The law also prohibits employers from requiring their employees to use sick leave. It's important to note that several California cities have local ordinances involving sick pay that may be in addition to or have alternative requirements other than the state law. If you have employees working in Berkeley, Emeryville, Los Angeles, Oakland, San Diego, San Francisco, or Santa Monica, be sure to research the city ordinance to ensure the company policy is in compliance with their requirements. When applied to employees working under an approved alternative workweek schedule of 4 10-hour days, those employees should receive 30 hours of paid sick leave, which equates to 3 days. When applied to employees who work less than 8-hour days, for example, a 6-hour day, those employees will still be required to receive 24 hours of paid sick leave, so in this case, they will receive 4 days. California organizations are not legally required to offer vacation time benefits. However, as with many other voluntary benefits, once an employer does offer vacation, there are rules and regulations about its administration. Under California law, vacation is an accrued benefit and is therefore considered wages. All unused accrued vacation at time of termination shall be paid at the employee's final regular rate of pay, not at the employee's rate of pay when the time was earned. Because of this, earned vacation cannot be taken away from the employee. Use it or lose it, vacation policies are illegal. Employers cannot require employees to forfeit accrued or unused vacation or PTO time for any reason, except by limiting accrual when a reasonable cap is in place. To control potential problems with large accrual banks, employers may implement a reasonable cap at which vacation or PTO will stop accruing, limit carryover from year to year to a reasonable amount, and/or allow or require unused vacation or PTO to be paid out at the year's end. The Labor Commissioner's guidelines put this limit at 1.75 times the employee's annual rate of accrual. When utilizing vacation, employers must pay employees based on their regular rate of pay. For commissioned employees, the rate of pay can be either an average of earnings over a reasonable amount of time or a set hourly amount regardless of earnings. To avoid disputes, employers should determine which method of pay will be used in advance and explain it in the employee's commission agreement. Employers can approve or deny an employee's request to use vacation, can require them to provide a set limit for notice of vacation needs, can schedule employees to utilize their available vacation, and can provide blackout periods when employees may not use their vacation. Employers can also determine the minimum amount of time that can be used for vacation, for example, 15 minutes, 30 minutes, 1 hour, and so on. Allowing an advance of vacation or a negative balance is at the discretion of the employer. However, time not recouped cannot be deducted from an employee's final wages if terminated without the employee's approval. Best practice, employers should require employees to complete a vacation request form or similar when requesting time off for vacation. In Ria v. General Atomics, the California Court of Appeal issued an important ruling confirming that employers may require salaried exempt employees to use accrued vacation or PTO time for partial day absences in any increment, including increments of less than 4 hours, without violating the salary basis requirements for exempt status under California wage and hour law. Employers can also decide whether or not they will allow their employees to go negative in their vacation balance. However, there are consequences of allowing negative balances when it comes to the employee's termination. employers may not require employees to pay back that lost time. Please see the compensatory wage and hours section for more information. Paid time off, or PTO, is a combination of sick and vacation time. Employers using a PTO policy allow employees to take their available time for whatever reason they would like. Like vacation time, employers can dictate guidelines as to how the PTO can be used. However, California employers that utilize a PTO program need to be sure that their policy allows use for at least 24 hours or 3 days for sick leave under California's Healthy Workplace, Healthy Families Act. This time must be held to less strict standards than the remainder of the available time. Like vacation time, PTO is earned time and is therefore compensable at the time of termination. Under California law, kin care refers to time off an employee may need to care for a sick child, parent, spouse, registered domestic partner, or child of a registered domestic partner. Prior to July 1 of 2015, employers were required to allow employees to use half of their annual accrual of sick time for kin care. With the enactment of California's Healthy Workplaces, Healthy Families Act, employers must allow employees to use at least half of their annual accrual of sick time for kin care, but no less than 3 days or 24 hours. For example, employers who are providing only sick time without PTO or vacation time must permit the use of 3 days or 24 hours of sick time, the full amount under the California Healthy Families, Healthy Workplace Act, to be permitted for kin care. If the employer is allowing more than 3 days but less than 6 days of sick time, at least 3 days of that time is allowable under kin care. Employers providing more than 6 days of sick time annually can limit the use of kin care to half of the annual accrual of sick time. If the employer has no limit to sick time, then there is no limit to the amount of kin care that can be used. Employers that have only a PTO policy that includes vacation and sick time need to allow the usage of at least half of this time to be used for kin care. Employers who provide sick time as a required California Healthy Workplaces, Healthy Families Act provision, and also an additional PTO policy that employees can use for vacation or sick time, need to allow employees to use all of their sick time and half of their PTO for kin care. Some employers do not track how much time off employees take. For employers with unlimited paid time off plans, the notice itemized pay stub or separate written statement provided with the payment of wages meets the requirements by indicating the paid sick leave is unlimited. Technically, this will not affect kin care as the employer is not tracking the reason for the time off anyway. A leave of absence is a period of time when an employee is away from their primary job while still maintaining employee status. California lists several qualified leaves of absence that employers need to know about and understand. These leaves of absence are protected, which means that employees cannot be negatively impacted or discriminated against by exercising their rights under these leaves. Employers must be sure to properly document all leaves of absence using a change of status form that notifies the employee of employer approval to take the leave and the dates of the approved leave, for example, May 1 to May 15th, including the expected return to work date. Some of the leaves that are protected under California law include time off to vote, jury duty or witness leave, workers' compensation leave, military leave, pregnancy disability, California Family Rights Act, leaves for victims of crimes, and leaves for school. Per California Election Code Section 14,000, all employers are required to allow their employees the opportunity to take time off to vote in statewide elections. If there is sufficient time outside their normally scheduled work time to vote, then no additional time off is required. Employees can be given as much time as they need to vote, but only a maximum of 2 hours is paid. Employers may require employees to give advance notice that they will need to have the additional time off for voting, and the employers may require the employee to take the time only at the beginning or end of their shift. Employers are required to notify their employees of this right by posting the required voting notice at least 10 days prior to the statewide election. If the employee would like to exercise their right to this leave, they must notify their employer at least 2 days before the statewide election occurs. In addition, employees can request time off to serve as an election official. The employer must approve this unpaid time off and cannot discipline or discriminate against an employee for taking this time. The time off to vote notice requires that employers post the notice advising employees of the provisions for taking paid leave for the purpose of voting in a statewide election, and it must be posted 10 days prior to the statewide election. If an employee is requested to serve on a jury or to appear in court because they are subpoenaed as a witness, their leave request must be approved. However, employees are required to give their employer reasonable notice of the need for time off for jury duty and/or to appear in court as a witness. Employers can also require employees to provide the summons as a proof of the need for the leave. Employers cannot discriminate against employees in any way if they need to exercise their right to these types of leave. For non-exempt employees, this leave time will be unpaid. Non-exempt employees can request to use accrued and unused vacation or paid time off during this time. For exempt employees, this time will be paid as long as the employee completes any work during any time in a work week. The administration of workers' compensation will be discussed in detail in the Health, Safety, and Workers' Compensation section. Only the leave associated with workers' compensation is covered in this section. All employees are eligible for workers' compensation on their first day of hire. No additional eligibility requirements for leave apply if an employee is injured in the course of performing their job. Following injury, the employee should be transported to the designated medical provider to determine the extent of their injury and to certify the potential requirements for time off. Once an employer receives medical certification that an employee's injury or illness requires time off from work, the employer must determine whether the individual is eligible under any other leave laws that should be run concurrently, such as FMLA or CFRA. Unlike other leaves, workers' compensation time off is not considered protected time off and is actually considered time worked. However, employers still must ensure that they do not discriminate against an employee for filing a workers' compensation claim. If an employee's protected FMLA/CFRA leave expires and they are still unable to return to work, the employer should request certification regarding how long the workers' compensation leave is expected to continue. Employers should do everything in their power to allow injured employees sufficient time off to recover from workplace injury or illness, and in the event that the employee is permanently disabled because of the injury, the employer should begin the interactive process to determine whether a reasonable accommodation request is feasible as required under the Americans with Disabilities Act. Employers violate Labor Code Section 132A if they terminate or discriminate against an employee for filing a workers' compensation claim. However, the longer the injured employee is on leave and unable to return to work at even a limited capacity, the more likely that an employer's adverse action, i.e. termination, will be considered justified. All employers are required to comply with the school appearance leave law. Employees who are required to appear at their child or ward's school because of disciplinary action are entitled to the necessary time off. Per the company policy, this time off can be paid or unpaid for non-exempt employees. Exempt employees will be paid for this leave as long as they conduct any work in the day they need to have time off. The employer can require the notice of appearance the employee receives from the school as documentation for this leave. Employers with at least 25 employees are required to comply with the school activities leave. An employee is eligible for this leave if they are the parent, guardian, or custodial grandparent of a child in a licensed child care facility or in kindergarten through 12th grade. This leave allows employees time off to participate in school activities for no more than 40 hours in one calendar year and no more than 8 hours in one calendar month. To be eligible, an employee must work for a qualified employer and give reasonable notice of the planned absence and provide participation documentation if required by the company policy. Parents who are employed by the same employer are required to share this time. Employers can deny leave for one of two parents if both request the time off. Employers can also require employees to use accrued vacation or PTO first. This leave is unpaid for non-exempt employees. Exempt employees must be paid for a full day regardless of vacation paid time off usage, as long as they conduct any work on that workday. California employees are afforded time off for two reasons when it comes to being a victim of a crime. These applicable leave laws allow an employee time off to attend to a judicial proceeding related to the crime, as well as a leave to attend any proceeding involving victims' rights. For an employee who is the victim of a crime or an immediate family member who is the victim of a crime, including registered domestic partner or child of a domestic partner, they are allowed time off in order to attend legal proceedings related to a violent felony, a serious felony, or felony theft or embezzlement. The employer is allowed to request documentation that the judicial proceeding is taking place. As this leave is unpaid, the employee can decide to use any and all accrued or unused vacation or paid time off to attend these proceedings. In the event of an emergency, employers are required to allow those employees who are volunteer firefighters, reserve peace officers, emergency rescue personnel, including officers, employees, or members of a fire department, California state government, local government, sheriff's department, or police department, and some healthcare providers, as well as members of disaster medical response teams, time off to perform emergency duties. An employer with at least 50 employees must also allow volunteer firefighters, reserve peace officers, and emergency rescue personnel a total of 14 days off per calendar year to engage in fire, law enforcement, or emergency rescue training. Further, employers are prohibited from discharging, demoting, suspending, or otherwise discriminating against employees who take time off for this purpose. The Uniformed Service Employment and Reemployment Rights Act, USERRA, is a federal law that protects employees who need time off from their regular jobs for military service. USERRA is one of the most protective employee rights laws on the books. It prohibits discrimination against employees who are in the military, have served in the military, or take leave to serve in the military. But it also requires employers to reinstate employees who take up to 5 years off from military service, with all of the promotions, raises, and other benefits they would normally have received had they worked through their time off. And it prohibits employers from firing employees without cause for up to 1 year after they return from service. USERRA protects employees who serve in the United States military, including those who serve in the Army, Navy, Marine Corps, Air Force, Coast Guard Reserves, Army or National Guard, and Commissioned Corps of the Public Health Service. If you work in California and you need time off for service in one of these branches of the military, you are protected by USERRA. As is true in many areas of employment law, California provides additional protections. Members of the California National Guard who are called to active duty are entitled to unpaid leave and reinstatement to their former position or a position of similar seniority, pay, and status without loss of retirement or other benefits. Employees must apply for reinstatement within 40 days after they are discharged and cannot be terminated without cause for 1 year. Employees who are in the Guard Reserves or Naval Militia are entitled to up to 17 days of unpaid leave per year for military training, encampment, naval cruises, special exercises, or similar activities. Employers may not terminate employees or limit their benefits or seniority because of an employee's temporary disability resulting from duty in the National Guard or Naval Militia for up to 52 weeks. And employers may not discriminate against employees because of their membership in any branch of the state or federal armed services. Employees that believe they have been discriminated against because of their military service or have been denied the rights available under USERRA or California state law should contact servicemembers.gov, the Department of Justice's website devoted to enforcing USERRA and other laws that protect the rights of those who serve in the military. California has a specific leave associated with disability due to pregnancy. As such, CFRA does not cover pregnancy disability as a serious health condition as it is under FMLA. Employees who work for organizations with at least 5 employees who become disabled due to pregnancy, childbirth, or related medical condition are entitled to up to 4 months of protected job leave under pregnancy disability leave. This leave is calculated using the employee's normal work week. A full-time employee is entitled to 4 months, or 17 1/3 weeks, or 88 days per pregnancy. Employees working for California government agencies, cities, and counties are covered by PDL regardless of the number of employees. If an employer offers extended leave time for other disabilities, then they must also provide the same amount of time for pregnancy disability leave. This leave begins as soon as the woman's doctor certifies that she is unable to perform the essential functions of her job due to medical conditions related to her pregnancy and continues throughout the time her doctor confirms that she is no longer disabled. Leave can be used for severe morning sickness and prenatal care, and as with CFRA and FMLA, leave under PDL can be taken intermittently. Since PDL is covered by the Department of Fair Employment and Housing, employees can also request a reasonable accommodation or a transfer. Each reasonable accommodation request is determined on a case-by-case basis. For a transfer, employers are not required to create a new position, discharge another employee, violate a collective bargaining agreement, move an employee who has higher seniority, or promote the employee to a position that the employee is not qualified for. Employees are not limited in an annual amount of time that they can be out on pregnancy disability leave. For example, an employee is disabled by her pregnancy in January and takes PDL. She loses the baby in March, and her doctor orders bed rest for 2 additional weeks. She returns to work in April. She used a total of 10 weeks between January and March. In September, she becomes pregnant again, and her doctor orders immediate bed rest. the employee is entitled to the full 4 months of protected PDL for this pregnancy. The 10 weeks that she took previously in the year for her initial pregnancy do not count against this new pregnancy leave time. Unlike CFRA and FMLA, employees are eligible for PDL upon hire and then are approved as soon as their physician determines that the woman is unable to perform the essential functions of her job because of the pregnancy. No other length of time employed or hours worked requirements will apply. Employers must accept verbal notice that an employee is requesting an accommodation, a transfer, or a leave. The employee should provide the employer with 30 days notice if possible. If that's not possible, they must notify their employer as soon as they are able. Once requested, the employer can require the employee to provide medical certification within 2 days, including a description of requested accommodation and/or transfer, the statement explaining the medical advisability of the accommodation or transfer or the requirement for a leave, and the date on which the accommodation, transfer, or leave is to begin, and the duration of that leave. Pregnancy disability leave is unpaid by the employer. However, employees may be able to collect state disability insurance benefits while on PDL. If an employee receives SDI benefits, it is up to the employee to decide whether to use any accrued and unused vacation or paid time off. If an employee does not collect SDI while on PDL, the employer can require that the employee utilize such time if that is in the company policy. As for sick time, the employer can require and the employee can request to use any accrued and unused sick time while out on PDL. Time out on PDL should not be considered a break in service. As with CFRA, PDL does not affect an employee's seniority status in regards to pension and retirement, supplemental unemployment insurance, life insurance, short or long-term disability insurance, and accident insurance or similar benefit plans. The employee is entitled to all seniority accrual that they would have received if they were not out on leave. It's also important to note that the employee's health benefits should continue for the full 4 months out on PDL. When employees are required to pay a portion of their health benefits, they should continue making those payments to the company, since no fund exists from which the employer can make the deduction. Upon request or requirement of PDL, the organization should notify the employee of their requirement to pay their portion of their insurance and set up a payment plan for submitting those payments to the company direct. However, as the full 4 months of PDL is allowable per pregnancy, the requirement to continue health benefits is only required for up to 4 months in a 12-month period, commencing on the date of the first leave. In addition, nothing shall preclude the employer from maintaining and paying for coverage under the group plan beyond the 4 months. If the employee does not return to work following their leave, the employer can recover premiums paid for health benefits during the leave time. In order to recover premiums, the employee will have failed to return from leave, and their reason must be something other than that the employee begins CFRA after PDL, unless they do not return after their CFRA leave, or the continuation, recurrence, or onset of their health condition entitles them to PDL unless they do not return from PDL, or it is a non-pregnancy related medical condition requires the employee to take additional leave unless they do not return from that leave, or any circumstance that is out of the employee's control. As with CFRA, employees out on PDL are entitled to reinstatement to the same position with the same benefits and seniority as they had prior to taking leave and affording all the benefits they would have expected had they remained employed. In some specific scenarios, reinstatement to a comparable position is applicable. Employers can require the employee to provide them with a return to work release before allowing them to return to work. Since taking the leave required medical certification, the organization should require a medical certification stating that the employee is able to perform the essential functions of the job and no longer limited by a pregnancy or childbirth-related disability. If company policy allows for longer than 4 months of protected leave for other issues of disability, the reinstatement requirements for PDL are the same length of time as under other disability leave policies. When an employee returns from PDL following childbirth, they may request time to express breast milk while at work. Under California and federal law, employers are required to provide a reasonable amount of time to lactating employees to express breast milk during the workday. Employers can require lactating employees to use meal and rest periods to express breast milk. However, if the employee requests additional time, time should be provided and can be provided unpaid. These requests should be approved through the child's first year of life. For full employer requirements associated with lactation accommodations, additional information will be found in Functional Area 5, Compliance and Risk Management. Employers must post notices pertaining to pregnancy disability leave pursuant to the number of employees. 2 posters are available, one for employees of 2 to 49 employees, and a second for those with 50 or more employees. If more than 10% of the workforce speaks a language other than English, the notice must be posted in that language as well. As soon as an employee informs her employer about her pregnancy, the employer must provide her with the notification pertaining to pregnancy disability leave. It is not necessary for her to request leave at that time. A notification of pregnancy should automatically trigger the handout. Employers with at least 15 employees are required to comply with the Civil Air Patrol leave. An employee is eligible for up to 10 days off in 1 year to fulfill their duty with the Civil Air Patrol. To be eligible, an employee must work for a qualified employer and be employed for at least 90 days with their current employer, be a volunteer member for the California wing of the Civilian Auxiliary of the U.S. Air Force Civil Air Patrol, be responding to an emergency mission, and provide certification from the Civil Air Patrol Authority if requested by the employer. Under this leave law, no single leave may exceed 3 days unless the leave is extended by the entity in charge and the employer approves the additional time off. This leave is unpaid, and employers cannot require employees to exhaust all available accrued leaves. However, an employee can request to use paid leave. Under the law, employers can offer this leave as a paid or unpaid leave. Employees returning from leave should be returned to the position held when the leave began. Under California law, an employee who works for an employer with at least 15 employees and donates an organ or bone marrow is entitled to paid leave benefits. Organ donors are entitled to up to 30 days paid leave, and bone marrow donors are entitled to at least 5 days of paid leave. Both are allowed only once in a 1-year period beginning when the employee first starts their leave. Assembly Bill 1223 expands existing leave entitlement for organ donors effective January 1, 2020. It changes the previous leave entitlement that employers with 15 or more employees provide up to 30 days of paid leave to organ donors in any 1 year. AB 1223 provides an additional 30 days of unpaid leave that be made available to organ donors in any 1-year period. Organ donors may collect paid family leave for the additional 30 days or may be eligible for state disability insurance benefits. To be eligible, An employee must work for a qualified employer and be employed for at least 90 days with their current employer and provide written verification that the donation is medically necessary. Employers can require that employees on organ donation leave take up to 2 weeks of accrued time off, whether it's vacation, paid time off, or sick. Those taking bone marrow leave may be required to use up to 5 days of accrued time. However, employers should have this written in their company policy prior to the request to use this leave. The time an employee is out on organ donation or bone marrow leave should be considered time worked with regards to salary adjustments, vacation PTO accrual, sick time accrual, or seniority. Employers are also required to ensure health insurance benefits are maintained during this time off. This leave cannot be taken concurrently with CFRA or FMLA. If the employee is eligible for either of these leaves and the employee needs additional time, CFRA or FMLA will start after the organ donation or bone marrow leave is exhausted. This time can also be taken intermittently. For example, if an employee on organ donation returns after 3 weeks off and after a couple of days requests additional time off, this employee still has 1 available week of leave. This concludes Functional Area 3, Part 2.